Okay, here we are. We are live. Good afternoon, everyone, and thank you for participating in this new webinar of the TRACE project. I'm very happy to introduce our speaker of today, my colleague researcher at the CNR National Research Council in Italy, Marco Fasciglione. Okay, sorry, I don't know if you hear a voice. Okay, so Marco is a researcher in the topic of human rights in business activity. He's a lawyer and an expert senior researcher at the National Research Council in Italy, Institute of Research for Innovation and Services for Development. So I will give the floor to Marco for describing the topic of today, for starting his presentation, and then we will have some time for Q&A. So you are welcome to write in the chat if you have any comment or question for Marco. And at the end, we will give time to answer, and if you want also to intervene later, you are also very welcome. Okay, so that's all from my side for now, and then I give the floor to Marco for the webinar of today.
Thank you very much, Antonia. Can you hear me? Okay. Let me express my gratitude for this kind invitation from your side, because you allow me to deal with important topic that I am dealing with and I am studying in my research activities at the Italian Research Council, and namely that very timely and an important issue concerning the policies, the developing framework on policies in the business and human rights arena. Of course, this is an important topic also from the side of the companies working in the tourism sector, and we will deal in this afternoon with a broad framework concerning the policy development in this area, and some hints concerning the evolution of the legal framework within European Union law, which is very important for companies, for the entire business sector operating within European Union market. I have prepared some slides, some PowerPoint presentation that I'm going to share. Here they are. Okay. Okay. I think that you all can see the slide presentation. Just a quickly addment to the presentation made by Antonia. Indeed, at the National Research Council, I am the principal investigator of some research projects concerning business and human rights, concerning due diligence processes in the field of the environmental protection and the human rights protection, which have been funded by competitive research programs, competitive research fundings at national and international level. I am also the co-director of a business and human rights summer school, which is organized since 2018 each year, Indeed, we have had all along the years a lot of success in terms of faculty members, in terms of participants who actually are from all over the world. So it's a wonderful occasion for the research students or also for companies, experts to deal with these kind of topics in an internationally sound environment. So that's those few things that I wanted to highlight. As far as the today today topic, my idea is to start very quickly to reconstructing the broad policy framework at international level concerning business and human rights. Then we will analyze some important instruments that have been adopted at the international level concerning business and human rights, and then we will focus on some developments occurring at the European Union level. First of all, the first question that I think is important to ask ourselves is why business and human rights movement is so important. Why we had this kind of shift from the so-called corporate social responsibility movement to business and human rights movement. The answer is obviously extremely complex, but suffice here to say that business and human rights movement is the reaction to some negative impacts, some misalignments that the globalization processes have created as far as the protection of the environment, as far as the protection of human rights worldwide, within corporate activities and corporate operations, and also all along the global value chains. These kind of effects of globalization and of capitalism are mainly maybe mainly described as putting business model, profit-centered business model at the heart of the business model, while there is the need to look for different alternative perspectives to traditional business model, which are much more aligned to principles concerning human dignity. So alternative business models focusing on human models, human-centered models. Another important element is the concept, the notion of governance gaps, that is the externalization stemming from the production, contemporary system of production, which are organized in terms of putting on third parties the risk of negative impacts stemming from the business operations, so that are externalizing processes. Of course, the law, the legal structure play a fundamental role from this perspective, because law regulates the corporate structure. No, business law is based upon the idea of the so-called corporate veil, that is the impossibility to attribute the conducts of parent companies of subsidiary companies to parent companies, and as well as the regulation of the value chains. Actually, in these moments, in these days, is mainly regulated by the law, by contractual relationships, which are exist among autonomous and independent entities. The path of the business and human rights movement is not something who has developed recently, but dates back the 70s, at the very least, the 70s of the last years. I mean, because it is in that period, in the 70s, in 1970s, that the first codes of conduct, the first international instruments on business and human rights, the first attempts to regulate multinational enterprises were adopted, with two basic instruments that are very important still today. That is the OECD guidelines for multinational enterprises adopted in 1976, and the ILO tripartite declaration on multinational enterprises and social policy, which was adopted 1 year later. These kind of instruments are part of the first wave of the regulatory attempt, which was lasted until the beginning of 2000, 2001, 2002, 2003, more or less. Then the second phase started in 2003, in 2004, more precisely, with the work made at the United Nations level by the Special Representative on Business and Human Rights. The Secretary General in 2004 appointed a Special Representative of Business and Human Rights in the person of Professor John Ruggie, an Harvard academician, who conducted a very long work of study, whose result was, in 2011, the adoption of the United Nations Guiding Principles on Business and Human Rights. At the moment, the United Nations Guiding Principles constitute the basic reference point for international, for the area of business and human rights at international level. So the main standards at international level in business and human rights are the UN Guiding Principle on Business and Human Rights. But as John Ruggie had the occasion to say, the guiding principles are not the end of the process of consolidating standards, but only the end of a first phase, of a first stage of policy development, which was destined according to Ruggie point of view, was destined to continue further in the successive years. And indeed, it was in this way, because from 2011 until today, we are assisting to a consolidation process of these standards via the adoption of legislation at national level, or even at supranational level, at regional level, but also we are assisting to the negotiations within United Nations of a Business and Human Rights Treaty. And so there is a lot of developments just today when we are speaking this afternoon on these issues. In this slide, you may see a very quick synthetic presentation of the main standards existing at the moment. That is the United Nations Guiding Principles adopted in 2011. On the other side, the already mentioned OECD guidelines for multinational enterprises, which have been revised several times. The last revision was made in 2023, which are as the UNGPs, but we will got back on this issue in a while, which are voluntary standards, soft law, that is not binding principles, but also we have normative hardening legislative instruments who has been developed. The most notable example is the Corporate Sustainability Due Diligence Directive adopted recently, very recently by the European Union in 2024, but we will see later the main feature of this kind of legislation. Let's turn very quickly to the guiding principle, because as I have already said, they are the reference point, the basic standard appeared at the international level in the business and human rights sector. Simply put, UNGPs rest on three pillars. That is, the first pillar, the state duty to protect human rights from the negative impact from the violations that may occur within corporate activities, in the context of corporate activities. The second pillar is the corporate responsibility to respect, that is a pillar concerning what business, what corporate actors have to put into place in order to avoid negative impacts on human rights and on the environment. The third pillar is the access to remedy pillar, that is those kind of principles that have to be assured in order to grant the access to remedy for the victims of violation of human rights. These three pillars have to be seen as interrelated, as interconnected, because without only one of these kind of pillar, the entire structure of the guiding principle may not work. I have anticipated that the UNGPs are not a legally binding instrument. They are a series, an ensemble of recommendations which are addressed to states and to the private sector, and which represent the first global standard on business and human rights. But while the first pillar, the state duty to protect, and the access to remedy pillar are simply put a simple restatement of principle existing in law, in international human rights law, the second pillar, the corporate responsibility to respect human rights, on the other side, on the contrary, creates something new. That is the expectation put to the business sector that companies respect human rights by identifying, preventing, mitigating, and accounting for how they address the negative impact on human rights stemming from their business operation. Simply put, that means, but we will see in detail, more in detail in a while, simply put, this means that companies, in order to abide, to respect corporate responsibility, to respect human rights, have to carry out human rights due diligence. Please highlight this this phrase, human rights due diligence, because this will be this is the basement of the entire business and human rights movement, and will be the basement of future instruments, of the instruments, even legislative instruments that have already been adopted, but also future instruments that will be further adopted at national or regional or international level. Does this framework that I have very quickly, very synthetically reconstructed, does has a role to play as far as tourism and travel industry? The answer obviously is yes, is positive, because as you may know, any kind of industrial sector is not free from the risk of a negative impact on human rights. This applies also to tourism and travel industry in terms of there are a lot of examples in terms of labor rights and poor working condition, in terms of health and security at work, in terms of modern slavery, in terms of exploitation, in terms of discriminatory practices towards vulnerable individuals, or also in terms of protection on the environment and climate change. Of course, when we speak of national legal system, maybe European Union law or developed countries' national legal system, normally these kind of issues are already subject of regulation and of laws. But as you may know, since companies are working and operate normally also along the value chains, along the chains of activities concerning different jurisdictions, different national states. Very often these other states interested by the production, by contemporary production processes are third countries, developing countries with poor human rights and environmental records. And here there is a risk. Here this is conducive, this is an avenue for creating, for involving companies, even when they have their legal seats in developed countries, for being involved in human rights negative impact or environmental negative impact. Let's see with more. Let's see more close. What does for a company what does mean to respect human rights? So exercise corporate responsibility with the aim to respect human rights. Well, UNGPs, the guiding principle, United Nations guiding principles, say us that business should avoid infringing human rights of the others and should address adverse human rights impact with which they are involved in. Specifically, the UNGPs tell us that companies have to avoid causing or contributing to adverse human rights impact through their own activities, and they have to address such impact when they occur. In addition, companies are also requested to seek to prevent or mitigate adverse human rights impact that is linked directly to their operation, their products, and their services, by virtue of their business relationship, their contractual relationship with third parties along the value chains. So causing, contributing to, and directly linked to are the three avenues according to which companies may be involved in negative impact on human rights. Please be aware that in the terminology of UNGPs, negative impact on human rights may be considered corresponding to violating human rights. So the corporate responsibility to respect, which is enshrined in the second pillar of the UNGPs, is not based on law. We are not speaking of a binding standard, but on the contrary, we are speaking of a standard based on a social expectation, which is put on private sector. So we are dealing with a standard of conduct. This kind of standard applies to all companies, so without any kind of difference, independently from the legal form, the dimension of the company, the sector, etc., etc., etc. So all the companies are, in theory, are potentially involved in the corporate responsibility to respect, because all the companies may have potentially a negative impact on human rights. I mean, also small, medium enterprises may have negative impact on human rights when they operate along the value chains. In addition, this kind of standard is also applicable everywhere. That means that it is not subjected to the jurisdictional power of national states. And from the ratification that states have made of international human rights law treaties. This is expression of a principle very well known in the environmental protection sector, that is the principle of common but differentiated responsibilities. That means all actors operating in international arena, states, but also non-state actors, have some responsibility in assuring the protection on the environment and of human rights. And so these responsibilities may be described as common but differentiated responsibility. And of course, the corporate responsibility to respect applies to international recognized human rights. Let's go further and let's see how to, in concrete, company may apply concretely the second pillar, this kind of responsibility to respect human rights. Here the UNGPs fixes some policies and processes that companies may put into place in order to operationalize corporate responsibility to respect. Mainly, there are three bases of policies that companies may put into place. That is, adopting a policy commitment, exercising human rights due diligence, and implementing remedial mechanisms. As anticipated, the fundamental basis of the second pillar is represented by the human rights due diligence process. What does it mean, human rights due diligence? Human rights due diligence is described in Principle 17 of the UNGPs, and UNGPs describe human rights due diligence, as a process divided in 4 phases, that is, identifying and assessing actual and potential human rights impact, integrating and acting upon the findings, tracking responses, and communicating how impacts are addressed. In this slide, you may see the human rights due diligence put as a project cycle because the UNGPs highlight the fact that human rights due diligence is not a single ballot process, a single ballot measures. On the contrary, human rights due diligence is an ongoing process which has to be performed periodically in order to reevaluate and reassess how the company impacts, if impacts, on human rights and on the environment. So you see the four basic phases of the human rights due diligence. Just to add some important notes, as far as the first phase, the identification and assessment, this is at the end of the day, it is exactly a typical human rights impact assessment, which is an instrument very well known. So the evaluation of the risk of negative impact on human rights is the basis of the first phase of the human rights due diligence. Another important point that we have to have into mind is that once evaluated the occurrence of potential risk for human rights, companies have to adopt consequentially measures in order to address this kind of risk. Well, measures to be adopted may not be the same for any kind of company, any kind of sector. On the contrary, measures depends on the context of the operating activities of the company, of the business sector, on the legal form of the company, etc., etc., etc. Finally, another important point to have in mind is that whatever kind of measures and actions the company perform in exercising human rights due diligence, everything should be object of communication to the public. So transparency is one of the pivotal elements of the human rights due diligence. This is the very same project cycle of human rights due diligence as we have seen for the UNGPs, but this is the graphic representation of the human rights due diligence under OECD guidelines for multinational enterprises in their evolving and revised editions. It is fully aligned to the United Nations guiding principles, so it is not important we can skip it at the end of the day. What is important to say is that we have to be careful in not in not considering human rights due diligence as the same thing of traditional due diligence, which is applied since long time in business law. Human rights due diligence is completely different from traditional corporate due diligence, because while traditional due diligence, the one applied in the securities, for instance, while traditional due diligence is an evaluation process which is aimed to detect risk for the company. So it looks at the inside of the company, within the company. Human rights due diligence has a completely different approach. That is evaluating the potential risk for third parties. So it is again a kind of externalization. Simply put, it's a reaction to externalization dynamics stemming from globalization phenomena. Again, corporate human rights due diligence is not is a standard of conduct, so it does not mandate companies to reach a specific result. It's an effort duty. I mean, companies are only requested to do whatever is in their hands in order to avoid the negative impact or addressing the negative impact. In principle, human rights due diligence may be applied to any kind of company. It is functionally depending of the type of the typology of the impact that is detected. So we should look to the probability of the negative impact, to its severity, which is its scale, the scope, if the impact is remediable or not. These kind of elements may push companies in developing different measures for addressing the risk of negative impact. Finally, human rights due diligence applies to all internationally recognized human rights. With this formula used by the guiding principles, Rugby meant, at the very least, referring to the Universal Declaration on Human Rights, which was adopted in 1948, the treaties adopted following the Universal Declaration, that the two covenants of 1966, the Sea Covenant on Civil and Political Rights and the Economic, Social and Cultural Rights, and in addition, the 10 core conventions of the ILO, which are the basis of the ILO Declaration of Principles and Rights at Work. How can companies implement human rights due diligence? Here are some very basic hints, but we could enlarge potentially this kind of list of potential measures. The first step is to adopt a public commitment concerning human rights. A statement, it may be included in code of conduct, in corporate code of conduct. There are also procedures and structures that may be adopted, created within the corporate organizations in order to decide how to deal with human rights issues. Big companies, big multinationals may be willing to create human rights offices with a team of experts in order to deal with human rights topic, but also smaller companies may have some resources concerning human rights with expertise in human rights, or they may also use external consulting. I mean, but it's important to have the capacity to deal with issues concerning human rights, the potential negative impact of corporate activities on human rights or on the environment. Also, companies may also include, and this is a technique which is already used in several contracts. They may use contracts with their business partners, putting in these contracts clauses concerning human rights respect, and this is a tool in order to exercise leverage, and enlarge the influence of companies towards its business partners. So due diligence may be applied also in the tourism and travel industry, in the tourism and travel context. There are some guides and guidelines that have been adopted in this field area. ILO has adopted some guidelines concerning decent work, while there is an interesting document report submitted by the UN Forum on Business and Human Rights, specifically dealing with human rights due diligence in the travel and in tourism sector. Let's turn now very quickly to the evolution of the European Union law, European Union legal framework, because European Union has started in 2001, so 25 years ago, more or less, in promoting corporate social responsibility policies within internal market. But since then, the path has developed towards a normative hardening, that is, towards adopting legislation, sectorial legislation, and then general legislation in the field of business and human rights, and mandating, in this case, binding duties for companies concerning human rights due diligence. So European Union has moved forward from soft law forward hard law. It has done this kind of development while developing a solid normative instruments concerning the so-called ESG, the ESG criteria, the criteria based on environment, social, and governance, which should be used in order to assess the environmental compatibility, the environmentally sound and the socially sound compatibility activities from private sectors. This ESG approach in the European Union law is fundamentally encompassed by these three kind of legal instruments: the regulation on taxonomy of environmentally sustainable economic activities, the corporate sustainability reporting directive, and finally the corporate sustainability due diligence. All considered, they have been defined as the sustainability package of the European Union, which is under review just in these days, but I will close on with some notes on this point. Well, very quickly, what about the corporate sustainability due diligence, which is the object of this afternoon speech? The Sustainability Due Diligence Directive is called sustainability, but at the end of the day, it's a human rights due diligence directive, because in the notion of sustainability, the European Commission, the European Union legislator, has put also human rights due diligence. It is a directive, so a specific, a particular legal instrument adopted by the European Union, which was adopted in 2024, which after a very long and very complicated negotiation procedure, a very complex legislative path, which was a compromise among different positions represented by several European Union member states. The aim of the directive is very important. The goal of the directive is to of course, advance respect for human rights and environmental protection, but creating a level playing field for companies operating within the European Union. That is, establishing simple and common rules for companies operating within the European Union. So in order to avoid fragmentation, the risk of fragmentation stemming from the action of single European Union member states. France and Germany had already adopted legislation concerning human rights due diligence, putting in some cases different different and clashing rules. So the action of the European Union was to harmonize this kind of rules, avoiding this kind of conflicts, which generates uncertainty for company sectors. Very important, which are the in-scope companies of the directive? The directive address only very large European Union companies. Big companies, these are the number of employees and the net annual turnover that should have been present for a company in order to be considered in scope. The directive applies also to non-European Union companies, so third countries companies, US companies, who operates in the European Union market. Importantly, the directive explicitly excludes small medium enterprises by the due diligence duty, so that by the obligation to develop human rights due diligence, but as part of global supply chains, small medium enterprises may be indirectly addressees of some due diligence steps, depending on their business relationships. The directive requires companies, in-scope companies, to identify, address a lot of kind of human rights and environmental impacts, which are listed in an annex to the directive. Labor rights, right to food, environmental degradation, loss of biodiversity, etc., etc., etc. And as far as due diligence process, the directive is basically aligned to the international standards concerning human rights due diligence, but it explodes the four phases, the four steps that I have described before as far as UNGPs in a wider series of steps of due diligence. Most important is the need, according to the directive, that due diligence be performed by engaging meaningfully with affected stakeholders. That is, to creating notification mechanism and complaints procedure and periodically consult stakeholders in order to understand which kind of negative impact is potentially connected to the companies, and which kind of measures may be adopted, and if measures have been adopted, which are their results. Also, the directive introduces some forms of support for small medium enterprises, which should bear some duty stemming from the human rights due diligence requirements imposed on big companies or in-scope companies. Companies are also required to create to adopt a climate change plan, a transition plan for climate change mitigation. But here there is a wrong narrative in the media on the directive. This is not a due diligence obligation. The obligation is only to adopt the plan. After that, there is not a due diligence obligation concerning the results and the effect of the transition plan adopted by the companies. Finally, the directive aspires also to reinforce the remedies for victims of negative impact on human rights and on the environment, and the remedial part of the remedial part of the directive is three-tiered. It's based on three bases, three pillars. First of all, company-level grievance mechanism. Complaints that may be submitted to the company grievance mechanism by individuals affected by trade unions or worker representative, as well as civil society organizations which operate in the value chain. So these are corporate grievance mechanisms. The second pillar of remedy is foreseen by the directive is the creation of a kind of administrative supervision and control, which is supervised by, which is tasked to a national monitoring authorities. So authorities to be established at a national level with a lot of powers, and namely ask information to companies. They may also investigate ex officio by their own on potential situation of non-compliance, or they also may be inspired by the submission of substantiated concerns submitted by potentially affected and interested parties. They may also perform inspection in the place, in situ. They may impose remedial measures on the companies and impose fine sanctions. Finally, and third pillar, the directive establishes civil liability scheme for companies if they fail to comply with due diligence, if they fail intentionally or with negligence to comply with due diligence provision fixed by the directive. Due diligence may be used as a defense in court. The burden of proof is on the claimants, so who claims to be a victim of a violation has to prove what he says. But the courts, the tribunals may order the disclosure of evidence when there are reasonable available evidences to support request for a disclosure. The implementation of the directive, member states have 2 years to implement the directive. And since then, since 2026, depending on their size, companies will have between 3 and 5 years to comply in order to abide to the directive. But in these days, exactly in these days, there is a new proposal, legislative proposal, submitted by the European Union Commission in order to amend some parts of the directive. Indeed, amending some parts of the entire European Union sustainability package, so also the taxonomy regulation and the sustainable reporting directive. But as far as the due diligence directive, it is included in this amendment process, whose objective, whose goal is to realize an harmonization, a further harmonization, a simplification of administrative and regulatory burden of companies, according to which probably because we have only a proposal, but now the legislative path has started and we don't know which will be the end of this path. Probably the proposal of the Commission is to reduce the ratione persone scope, so reduce the scope in the value chain of obliging European companies to realize due diligence only in respect to the first tiers, the first direct business partners. And furthermore, probably the EU civil liability, the civil liability harmonized under EU law will be removed. And at the end of the day, the idea is to leave to national laws, to national member states, legal systems, to define liability regimes and and how to apply civil liability scheme on their national legal system. And finally, the proposal is to postpone of 1 year at the very least of the entry into force of the obligation for member states and for companies. Which the conclusion of this speech, of this reflection that I have made with you. First, business and human rights is a train that is picking up speed. So it has started from with soft law instruments, but it has developed further towards normative regulation. In some, it is getting day after day, year after day speed. We have some legislative instruments, of course, at the national level, at regional, European Union regional level, but other instruments are in development. Even if there will be amendments to the directive, the basic point is that the legislation will be in place, will remain in place, will remain applicable, and companies will have to organize their internal processes, their organization, in order to assure compliance through their management system to this kind of legislation, and speaking of European Union, of the directive. So finally, they must be prepared. So the best idea, the best would be to anticipate the change in order to be prepared once the duties will be into force. Here there are some references that I have also mentioned during my presentation. Of course, I remain at your disposal and available for you if you have some need for additional references. And of course, I am available now for any kind of question, of curiosity you may have. Many thanks. And sorry if probably I have go a little bit long.
No, thank you very much, Marco. It is really timely and important information for the companies, and we thank you so much for your presentation. I see someone is also writing in the chat some comments and highlighting how important it is to support, especially the small and medium-sized companies, to be updated with legislation to implement all the necessary measures. We have seen that this regulatory framework affects mostly the big, large companies. However, SMEs are part of the value chain and they can be indirectly affected. I think this is very important to know for the companies participating in our project Trace. Also because in the tourism sector, probably there is an issue in the human rights, especially with workers. Still today, we have a lot of people working with temporary contracts, seasonal contracts, and sometimes this can be like at the border, let's say, of the what we can call human rights, or we see working conditions that are not exactly the best for the workers. So what do you think, Marco, about this? Because our sector is a little bit special in this.
Yeah. You have put on the table two very important issues. Of course, like any other kind of industrial sector, tourism sector has some risk concerning human rights. You have mentioned poor working conditions, so the so-called right at work risk of negative impacts, and that is, of course, an issue, but there are also much more big issues from a human rights perspective. Let's think to sexual exploitation of children. So there are a lot of human rights risk even in the tourism sector. And I think that the movement in the tourism sector is perfectly aware of this kind of risk, and there are a lot of initiatives that are trying to address this kind of situation. So that's a very important and positive. The other point that you have mentioned and that I see in the chat has been also mentioned by Mary, is the role of big companies, but also of state authorities, in supporting small, medium enterprises. Because we know very well that international standards on business and human rights tell us that all the companies, all kind of companies are subjected to corporate responsibility to respect human rights and to human rights due diligence. Okay, that's a basic tenet. But of course, we cannot forget that small, medium enterprises have not human resources, economic resources, expertise resources for dealing with human rights issues like giant of the industry may have. So there is the necessity that any kind of framework, of legal framework concerning the duty of due diligence in human rights in the environment took into account these kind of points, this kind of invisibility of small medium enterprises, by adopting consequential measures, that is, measures of support. And interestingly, despite the critics towards the directive, and despite the narrative that has been made also in Italy by some kind of media and of lobby sectors, the directive does not punish, does not address small medium enterprises negatively. The directive requests member states and big companies who are in scope to create conditions for supporting small medium enterprises once and if small medium enterprises should have to face due diligence steps because of their business contractual relationships. So that's very important. That's, according to my point of view, it's an added value of the directive because it puts on the books, on the legal books, the fact that small, medium enterprises need support from states and from big companies. And while the narrative, the contro-narrative made was that the directive affects negatively the small medium enterprises, putting excessive burdens on small medium enterprises. This unfortunately, or fortunately, if we look to the directive position, it is not true.
Okay, thank you so much, Marco. This was also important to mention because you know that you're a lawyer, and we, as not lawyer, we people work in different sectors are quite sometimes scared about all the new regulation, new framework, and which will be the burden for our activities, especially owners of companies or small companies which could be affected by having an excessive burden, excessive documentations to prepare and so on. And I see it very positive what you mentioned now and also during your presentation that also at the European level, the idea is to simplify and to not add other bureaucracy, let's say, but support the small companies, the SMEs, and give them all the instruments to be in line with human rights, with the regulatory framework, and without having an excessive workload, let's say, to be compliant with that.
Yeah,
So
yeah,
it's
that's the point. Yeah.
important. Yeah. Finally, I would just mention another point which I see very important is this link between environmental protection and human rights that you also mentioned in some way. So, because environmental protection is not only for the sake of environment, but also, of course, for people, for having better life conditions, for having a healthy environment for all, for our children, for the future generation, for the present generation. So this acknowledgement that environmental protection is a human right, and
Yeah,
we
yeah,
are all engaged in that. I find it also very relevant for our company's interests.
absolutely. Thank you. That's another important topic that you are raising. And yes, indeed. You know, human rights lawyer, international human rights lawyer have been speaking for years of the human rights status of the right to environment, and there are plenty of articles and books written on this issue. At the end of the day, thanks to the action of international organization and namely United Nations at first, today we have the clear acknowledgement that we have to protect the environment not only for the environment protection per se, but also because there is a strong human rights dimension when dealing with the environment, because environmental degradation, the loss of biodiversity, the degradation of the air, of the soil, are also situations which are potentially drivers of human rights infringements, human rights violations. So this is a point which nowadays it's fully acknowledged by the international organization, by the International Court of Human Rights. The European Court of Human Rights has developed a very broad case law on this issue. And of course, the business and human rights legal system as it exists today is perfectly transpose exactly this approach also within the movement and the human rights due diligence processes. So when companies perform human rights due diligence, they have also to consider the potential negative impact on the environment, which may cause interference on human rights. So that's absolutely correct, your point.
Okay, okay. Thank you so much, Marco, for your expertise that you have put at the service of the Trace project of our company. So
Thank you.
this is so interesting, and it's a topic that really is not often mentioned in such projects like ours. So I thank also all the companies, SMEs, registering for this webinar and participating and taking active part with writing comments and questions. I see that someone is still writing. So this webinar is recorded, and everyone will be able to look back at some information. We will ask you, Marco, if it is possible to share the slides, if you
Yeah, of
want.
course, no problem. I will send you in order to share with the participants.
Oh, thank you so much. That will be really great. And yeah, so for any question or request of support in this topic, we are here. I speak to the companies participating. We are here. You can write us, and in case you want to have contact with Marco, you have also his contacts in the last slides he showed. So for now, I thank you all for this interesting afternoon, and we'll see each other at the next webinar.
Thank you. Thank you to you. Thank you for your patience, and thank you, Antonia, for the invitation. See you.
See you. Bye.
Bye. Bye.